Hello and welcome to 4IP Council's webinar, Why Researchers Need an IP Strategy. My name is Claudia Tapia. I'm the chairperson for 4IP Council, and I will be your host today. As you may know, 4IP Council is a not-for-profit research council developing high-quality academic insights on topics related to IP and innovation. We collaborate widely, and I would like to thank ASDP, the European IP Help Desk, and WIPO for the marketing support given to this webinar. We also conduct education activities, including the creation of resources to encourage innovative SMEs to grow their businesses using IP. Among these resources, you will find interactive graphics, complementary topics, or presenters we'll cover today. Visit our website for a range of free materials. The slides and a recording for this webinar will be made available on our website tomorrow. If you have questions during or after the presentations, please post them in the Q&A area on your screen. And please allow me to introduce you to our two great speakers. Our first speaker, Dr. Peter Oksen, is Senior Program Officer at WIPO Green. Peter has over 20 years' experience in social economic development and natural resources management, both as an academic and as a business consultant. Before joining WIPO in 2018, Peter led the Danida Environment Support Program in Indonesia and developed environmental and social safeguard approaches and tools for the World Food Program in Rome. Our second speaker, Koenraad Debackere, is Professor of Technology and Innovation at the Faculty of Economics and Business of KU Leuven. His research has focused on the design of technology and innovation management practices and policies, the development of indicators for measuring the societal and economic impact of science and innovation policies, the role of entrepreneur universities in economic development, and the management and growth of technology-intensive companies. Since 1999, he has been actively engaged in technology transfer activities as Managing Director of KU Leuven Research and Development. He has led to experience with the growth of technology-intensive, innovative entrepreneurial companies. So without further delay, Peter, the floor is yours.
Thank you, Claudia, and welcome to everybody. So I come from the World Intellectual Property Organization, and just a few words on that. This is one of the 15 United Nations specialized agencies and was created in 1967 with quite a number of member states, and you can see there. Now, the reason that the UN goes into something like intellectual property rights is that it is a system that also can benefit greatly into innovation and creativity, and can also, and with the aim of developing a balanced and effective international system that all countries can benefit from. So basically what WIPO does, we do not provide patents, but we provide a filing system, international filing system that makes it easier for inventors to obtain IP protection in various areas. There's also a very strong capacity development mandate with us, and if you visit our site, you will see that there's quite a number of resources available for training and for education. Next, please. Next slide. So I will start out with talking a little bit about the general benefits of IP and what IP, what the assets actually are, what the tools are out there. Then especially in relation to research, of course, and then I'll show a few cases that can illustrate some of the points that I'm making here. And then in the end, I'll talk a little bit of where a particular office I come from in WIPO called WIPO Green, where we also have some tools that may be relevant for some of you who are listening there. So basically, the intellectual property rights system is a system that aspires to secure the rights of the inventor of a new technology or anything. So every time a new technology is out there, there is somewhere there is a rule, or there is an owner, and the IP system can help clarify some of these rules of interaction, and they can do it relatively early on, which can avoid a lot of problems further on. It is a system that is based on national laws and international treaties, and this is basically where the protection aspect comes in. It's not just a piece of paper, it is actually something that's inscribed in laws and backed up by quite a number of procedures. If you have secured IP rights when you have a new invention, there's much better chance that the technology transfer and diffusion of this technology, or whatever it is, will be more successful. And that's basically because you have a better chance of avoiding any misunderstandings or any conflicts that may come further down the road. It's also something that can be very important for investors in your technology because it lowers the risks, because it actually indicates that, well, the rights have been secured and therefore there's less risks of various infringements and conflict further down the road. And all that, of course, is good for business. In some arrangements, for example, public-private partnerships, it may, in some countries or in some circumstances, actually be a demand that these IP rights have been clarified exactly for the same reason, not to create problems later on. And then finally, it can also give the small developer or the more disadvantaged country a level playing field, because then they have something very tangible to negotiate with, and with a right that cannot be, so to say, ignored. Next slide, please. So the intellectual property rights consist of various, you can call them assets, or various, assets. So depending on what you are working with. So if it is a product or a process, well, then we're talking about patents. Otherwise, we have, as you can see on the screen there, trademarks, design rights, copyrights, geographical indications. Those are probably not so relevant for what we are talking about here today. But trade secrets could be, and trade secret is a little bit special, and I'll get back to that later on why we're mentioning that here. But that is also considered as a sort of intellectual property rights asset. Now, the whole intellectual property tools that we have here, the assets, so they're part of a larger, let me say, innovation ecosystem. And that means that each country have this kind of all these processes that are behind to backing up the whole innovation process. And that comes right from investment, education, research and development, and so on. And it can be many, many factors. For example, at WIPO, we produce something called the Global Innovation Index every year. And in 2018, for example, I just looked it up, they used more than 80 indicators for innovation in a country. So it can be many, many factors that contribute to this. Now, these IP assets is one of those. Next. Now, the idea of the patent is that you are granted a right from the state for a fixed term. Generally, this is 20 years, and it applies to a specific territory. That means the country or the territory where the patent is applied for. So once the rights have been given, then they can be enforced in courts if there are any problems. And it can also be challenged before it's granted, for example, through administrative procedures, if there are any disputes over whether this is really a new invention or not. Once a patent owner has got these rights, then this person can then decide how the invention is going to be used and by whom, for example, during the protection period. So you can decide whether you want to transfer it, you want to let it completely open for everybody to use, you want to license it, you want to sell it. Basically, it's up to you what you want to do with your invention. Now, after the expiry, typically these 20 years, then it goes into the public domain, meaning that there is no protection anymore. And then it becomes part of this global technological knowledge. So what is really also interesting about the international patent system is that it generates a really big repository of technological knowledge. This technological knowledge is publicly available because the principle is that you're granted a right, but in return for that, you have to disclose the details about your invention. And those details have to be so detailed that that people can basically redo it or can improve on it and continue to develop it. Of course, they don't have the right to do any commercial aspect of that when in a country where it's protected, but in countries where it's not protected, they can. And they can, of course, continue to develop it. So therefore, it is a system that promotes creativity and innovation because all this information is there. And you may ask, where is this information? Well, look at global databases. So here in WIPO, we have something called Patent Scope. There's more than 72 million patents. European Patent Office have, I think, more than 100 million. Even Google has made something called Google Patent Search. So there are many places where it can be searched. So these are huge, openly and publicly available databases. Next. So in essence, what a patent does when it's granted in a country, so it means that no third party can apply a patent for the same invention, meaning that you kind of block your invention in this space. A country where it's granted, it's you who decide as a patent owner what you want to do with it and where. And when I say in a specific country, it's all the time because the patent system is governed by national laws. There is no global patent. There may be some regional patents. For example, in Europe, there's a regional patent. There's in Africa, there's in the Middle East, where there may be some specific conditions that apply, but the enforcement of that is still within the state regime. So this is where I said that WIPO is managing some treaties. So these are international treaties that govern this whole system, but in actual practice, it's up to the individual states and their laws how they deal with this. So that's why something that you can get patent for in one country, you may not be able to do in another country. And that's simply how the international system works. Now, if you are working in other countries where you don't have registered your patent, well, then a third party can, in principle, copy and sell the invention, but they cannot patent it, but they can use it. So that's also something when we talk about green technology, you sometimes hear that patent system is a hindrance for development of green technologies, but actually in most developing countries, there's not really haven't been applied for many of these green technologies, for the simple reason that it's probably not worth it because the markets are not necessarily very big. So that means that if the patent has not been granted in that country, well, anybody can, in principle, use that invention. Now, if you don't have a patent, then you risk that a third party will try to patent the invention that you have and use it commercially. So in very simple words, it protects against third-party patenting, and it protects against a copy in the country of patent. Next. So the other aspect of this thing is that when then you get your patent, well, then one of the things you can do with it, you can license it out to a third party. So there are, I'm just very briefly going to mention that here because one of the case studies is going to show some of this, but if you basically have these four sort of general options, there are many more options depending on how you do it. It's basically up to what you can negotiate, but very often it's a matter of doing either non-exclusive. So that means that several people can be licensed at the same time or several companies. So that very often means that you get a lower price, but you get the invention much more out there. It can be an exclusive licensing, meaning that you only give it to one specific company to do this. So that may mean that the prices are kept higher, that there is less uptake. But some argue that this can also lead to more innovation because there is much more incentive for coming up with alternatives or new developments in this area because it's expensive. Then there's package technology licenses where you package together with, for example, know-how, software, training, so on and so forth. And then finally, there's compulsory licensing, and that's something that can happen under very special national urgent emergency situations. For example, in relation to medicine, where a company can be forced to enter into some licensing. But it's not a free license. There are various rules about it. It's very complicated, and it's not used that often, actually. Next. So shortly about trade secrets, because this is when we talk about patents and not talking about copyrights and the other things here, but we talk about patents, then the only real alternative that exists to that, if you are an inventor or you have a technology, is basically keep that technology or parts of it as a trade secret, basically keeping a secret. And of course, you could imagine that, you know, a physical gadget or something that you can take apart, you can't really keep that as a trade secret. So it's very limited where it would actually work. Illustrated the Google search algorithm. That's an example of a trade secret. For example, you probably heard about the formula for Coca-Cola is also kept as a trade secret. And how do they do that? Well, very typically, the tool they use for that is to have a confidentiality agreement with your staff. And if they break that, well, then you can pursue them in court. But the protection depends very much on the legal system and the definition of and how a trade secret is treated and respected. It depends from country to country. So compared to patents, it's a weak and quite risky way of protection, but it may be an option. And of course, when you have pending patents, when you have applied for a patent and haven't got it yet, then of course you will have to keep it secret if you don't want to risk it to get out there prematurely. So that's just to mention that that option is there, but it's not a super good option. Next slide, please. So a couple of cases here. So the first one here is of Dr. Ramon Baba from the Philippines. So he discovered a specific way to make mangoes flour. He didn't really think about taking a patent on this until he certainly discovered somebody else was trying to patent his invention. So therefore he contested it, and he was awarded the patent in the Philippines. Now then, this patent then helped Dr. Baba there to secure his rights and to share it with a number of beneficiaries, because he was not interested in using this for commercial exploitation. He basically just wanted to be out there. But if somebody else can come in and patent their thing, they could basically block others from doing it or start to make a commercial exploitation of it. Next, please. So here is another case from Argentina. So this is a company that developed inoculant for soybeans, as you can see here. Got a patent in Argentina. Wanted to go international. So what they did, they tried to find some distributors in various countries. Found out which markets in which countries are interested, applied for patents in these countries, then went into these countries through their local distributors, and was quite successful in that. Next. Here is another case from France with a public research institution in agriculture. So they had a method for producing high-yielding rapeseed. So they went for a non-exclusive license, meaning that it came out to a lot of different companies who could put this to market. And they then developed local specific varieties, and that got it even further out. And still, they actually made quite a lot of money, as you can see on it, through royalties. The last case, next please, is maybe a little bit special case, but this is about a Chinese researcher who quite a number of years ago found a new medical treatment and didn't apply for a patent, most likely because at that time there wasn't really a patent system in China. Another company in another country applied for it, and they did reach a deal at a certain time, but still China gained very little from it. But nevertheless, Chu Yu won the Nobel Prize, so she was credited for her invention. Next, please. So in general, when to think about IPR, so in general, as soon as possible. If you have a research and development phase, make an agreement on that, so it specifies who has the ownership when it comes out at the end. Definitely before deployment, because as I mentioned, reverse engineering is not illegal. You could consider doing a patentability test, so you hire a consultant or law firm to do that, and that can help you to understand which elements of your invention are actually worth to patent and where. So it's very much a business development idea and could be very good. And then you should also remember that even if you don't want to use your invention commercially, it might be a good idea to secure your rights anyway, to make sure that it stays free and open and public. Next, please. So with this, I will just finish off with a few words of what I come from in WIPO Green. So basically, we are a platform where we accelerate adaptation, adoption, and deployment of green technology. And we do that through doing a network and through a database. Next. So one of our activities, for example, is a major database where we collect technologies and needs from people who are looking for solutions. So it's a place where people can connect. It's relatively single as it is right now, but we're in the process of completely redoing it. So over the next few months, there will be a lot of improvements to this. It's all free resource. So if you have a technology that you would like to get out there, would like to know more about people who may be looking for solutions, you can just sign up on our website and you can upload a description of your technology. Just remember, there is no IP protection related to this. This is purely a public resource, freely available to everybody, basically. We also do matchmaking projects, so we try specifically to go in specific areas together with local partners, very often local IP offices, and try to identify which needs are out there and find technologies. And right now, we are running one with Chile and Argentina and Brazil in climate smart agriculture. Next. So this is an example of technologies we have in there. For example, a completely self-contained unit that can produce water from the air humidity. It can produce about 6 to 10 liters of water like that, one unit like that. But just to show the kind of things that we have in our database. Next. So basically, go to that web page there, and you can upload your technologies and look for needs. We also have a licensing checklist on our webpage, which might be useful for you as a walkthrough of things that you should consider if you're starting to license. It's a free download also. And if you want to know much more of these things, go to WIPO Academy, where there's a lot of training. There's a patent scope database to look for patents, and there are several other resources there. It's quite big. So with that, I'll thank you and leave the word to Dr. Koenraad.
Thank you, Peter. Thank you, Claudia. So what I will do is building on Peter's presentation and taking the perspective of an academic context, a research context, because very often academic organizations are discovering and understand why researchers need an IP strategy. Next, please. Researchers, I just want to give some famous persons here. Researchers von Harnack, who is the founder, not the founder, but whose principle on research is driving the Max Planck Institutes in Germany. And Vannevar Bush, who wrote that famous book, Science, the Endless Frontier. Those are two researchers that have really shown what research is all about. It's about changing the frontiers of knowledge. It's about discovering new know-how, but it's also about sharing that knowledge. And that, of course, is a very specific dimension of academic research, namely the fact that researchers are there to discover the world and to share their discoveries with what happens in the world, and also by extension, their inventions, once they start exploring new technical capabilities, new functions of particular components and technologies, etc. But today, and those are the two other pictures you see, one is the fusion reaction in Cadarache in France, ITER, and the other one is the Francis Crick Institute, DNA research, life science research in London. At the same time, this fundamental research, this discovery-driven research is becoming increasingly intense in terms of needs for infrastructure, in terms of budgeting and funding, which means that governments and academic institutions also have a duty to bring the inventions that have been made in those environments to market, and if possible, to generate a return from those inventions. Next, please. And even more important, it's not just about science in the academic environment today, but it's also about innovation. It's about turning science into not just knowledge that can be used, but also products, processes, services that can be used and that can be turned into viable market propositions. And also material from recent work by Dalander and David Gunn. They show us that essentially we come from a very entrepreneurial-driven innovation process to, in the 20th century, a highly corporate endeavor. You had Philips and NatLab in the Netherlands, ICI Labs in the UK, etc. So innovation being driven by large corporates, and today we add a third layer, namely innovation being driven by entrepreneurs, corporates, research institutes, academic institutions in a much more distributed environment. So science, the search and quest for fundamental knowledge becoming increasingly resource intensive, focusing on knowledge that can be very relevant to societal and economic problems, and at the same time, innovation turning that science into application, into market and societally useful applications that happen in a much more distributed manner. This is the context. Next, please. In that context, we see that both economists and scientists start understanding that what we do in the lab is extremely important in what happens in the market. You have the seminal paper by Robert Solow, who already in the 50s examined the impact of technical change on growth and productivity, and he came to the conclusion that technical innovation, R&D activities are the major driver explaining economic progress. And on the other side, you have a very recent paper by Ahmad Poor and his colleague Jones, show that the link between science and technology and inventive activity and patenting becomes increasingly intertwined, and actually who show that over 80% of scientific research ends up in the claims of patents these days. They searched and they did data mining on the US patent database, hundreds of thousands of articles and millions of articles and patents linked to one another. And we also see that universities are active mainly in the basic science, so that's the funding side, but increasingly also in applied science, while companies have become more or less absent from the academic science or from the fundamental science base, meaning that university and industry really complementing one another. And this means that also in an academic setting, next please, also in an academic setting, we need to focus on how to manage intellectual property and how to bring this intellectual property to impact. Those are just from my university, from Leuven Research and Development, some of the examples of scientific breakthroughs, scientific progress that has been translated into specific products, and those products have all been protected by patents and have all been instrumental. Those patent activity has always been instrumental in bringing the invention to the marketplace. Just to take a few, you see on the hand side, you see the HIV products that are brought to market by Gilead Sciences. This is a nice example of fundamental science done in cooperation between different university labs, has been brought to market and has been brought to treatment of millions of HIV patients. And of course, there is a solid IP portfolio that has been developed around those products. On the left-hand side corner, upper corner, you see a suitcase. Well, this suitcase was a first composite material suitcase that was developed by Samsonite, and a lot of knowledge both tacit but also patented, has been at the origins of that suitcase, showing how fundamental insights into composite materials are translated into market relevant products. And that's what researchers in academic labs are doing today. And that's of course why IP matters to those researchers. And that's also why as academic institutions, we have to show our researchers how they can tackle those IP issues. Please. So this is the reason why we need. Peter has highlighted a lot of the specifics of patenting. What I want to do is to show how this gets connected to organizing your R&D activities in an academic setting today. So what we say is, well, essentially our researchers have to link to companies and to society, and in building that link, intellectual property becomes an extremely important, alongside their publications, an extremely important dimension. And within the organization of what I call connectivity to industry and transfer of technology and knowledge, it is important to have a number of instruments that can be used. And actually, in technology transfer and intellectual property in technology transfer, there are three different instruments that are highly useful and much used. There is a lot of contract research going on with companies. And of course, during this contract research, IP is developed, or IP is shared, or IP is transferred, depending on where it originates. So we really have to understand within an academic setting who owns the intellectual property and where did it originate, the academic part, the company part. And that's why contract research and contractual arrangements along and around IP are critically important, and it's relevant researchers to understand how they have to deal with this. And that's why you need technology transfer activities and offices within a university. But on the other side, you see spin-offs. And just an example, over the last 12, 13 years, we have created over 100 spin-off companies in our university. And those spin-off companies, although the university invested like 12 million euros in starting the spin-off companies, they have been able to obtain over 1 billion euros in equity funding from third parties. And this is also one of the reasons why we have to show and teach our researchers that intellectual property is important, because if you want to attract this type of investment portfolio, you need solid intellectual property foundations of those spin-off companies. So we have a triangle of activities in stimulating technology transfer. It's about licenses and IP, it's about contracts, and it's about spin-offs. But without intellectual property and without a proper understanding of intellectual property by your researchers, you will never be able to achieve this type of outcome, this type of impact. And as said, type of impact is increasingly important also in view of what governments and public authorities demand for the public funding they give to academic institutions. Those are increasingly important in order to generate economic and societal impact from the research we create and we generate. Next, please. This means that you need a professional organization, a professional technology transfer organization. And as you can see, this is just the example of Leuven Research and Development by way of a small case study. But you see that you need to understand the three different pillars: research collaboration, linked to intellectual property rights in and of themselves. And there we have the whole plethora of possibilities. It's not just patents, it's databases, it's copyrights, it's trademarks, it's all the different dimensions of intellectual property rights that you have to deal with. And you see the link with spin-off activities and spin-off companies. If you want to do this in a professional manner, then you also need financial and HR support for your research community to make sure that your researchers get trained, to make sure that your researchers are aware of intellectual property education, etc., etc. So this means that if you want your researchers to understand intellectual property, you also have to create the appropriate organization. And I know that, of course, in companies, IP has been managed professionally for many, many decades, for many, many years. In universities, this is a relatively new phenomenon, meaning that building this type of activity and organization requires proper attention also by the management and the policy scene within a university. Next, please. So that being said, if you want to have this professional technology transfer organization linking and putting intellectual property at the core of what researchers need to understand, then a few highlights. It means that you need to deploy all components of your academic IP portfolio. So I already mentioned, but this is what we do, for instance, in professional technology transfer organizations these days. It means understanding patents, copyright issues, database related issues, and definitely in the era of GDPR, it's critically important that you take along your researchers on that journey. Design rights, trademarks, software, trade secrets, know-how, all those components are also in an academic environment extremely relevant. Of course, if you want your researchers to understand intellectual property and the importance of intellectual property, you need to provide the proper incentives, both for your researchers for the companies. For the companies, it means that they need to get access either by transfer or by exclusive or non-exclusive licensing, depending on the type of inventions they want to use and the way they want to use them. But there should be for companies an incentive to get access and to use that technology and those inventions. For researchers, there should be an incentive in engaging with patent activities alongside their publication activities, and this that whenever a financial return occurs, and we know that financial returns are highly skewed in academic environments, so most of the patents will never generate a proper financial return, but still we need to provide incentives to the researchers so that when they have costs in patenting, they are supported in doing so, and when there are returns, they can have to their research groups that can foster the further development of their research activity. Of course, you have to be sure that this is supported by a professional staff, IP educated staff, IP attorney trained staff at the Technology Transfer Office. And this is an investment that most universities are making today. And if they don't, they definitely have to make it, because if you're not supporting your researchers with proper technical patent-related expertise and advice, then it will go nowhere. You need supportive infrastructures and platforms. In Leuven, we created the Center for Drug Discovery, Drug Development to aid our research community in setting up new drug development trajectories that might be of interest to industry, but that are still way away from being able to be transferred to corporate settings. So therefore, we have a kind of bridging platform called CD3. We need to combine IP protection and professional licensing. And of course, we have to make sharp strategic focus and selections with respect to scope, sectors, geographies. We want our researchers to cover whenever they come up with IP that is valuable to protect. So this means that we have to professionalize and we have to understand the full process of IP development, IP protection, IP transfer within an academic setting. And that's where the Technology Transfer Organization plays a critical role. Next, please. Meaning that, as you can see on this slide, a lot of operational tactical activities have to be done, but it's also important to train with a sufficient level of sophistication your technology transfer officers and the scientists, both at senior and junior level. We need to understand co-inventorship and co-applications, because quite often we co-invent with companies, we co-invent with other research organizations. So this means that you need to understand how you're going to share the intellectual property that has been jointly created, meaning you have to develop models of rights and revenue sharing. You have to agree on who will take the initiative in exploiting the intellectual property. Assume that you are 3 universities joining forces in a particular scientific journey leading to IP, then you have to make good arrangements with respect to which organization is going to take the lead in exploitation initiatives. We need to take into account that in a scientific environment, publication is always key. So balancing publication and protection approaches is very important. And of course, code of conduct, conflict of interest is something that we should always be aware of. So universities that are professionalizing their IP activities, their tech transfer activities, they will also have appropriate code of conducts in place. And I refer to a LERU advice paper, so the League of European Research Universities, that was published in 2012, and that tackles those subjects. Next, please. So, in order to come to a conclusion, I would like to stress a number of issues that are on the agenda today. Of course, you need the organization, you need all the basics and the specifics, but the complexity of IP ownership and exploitation in multi-partner public-private consortia is increasing. So the Horizon 2020 setting, for instance, and the Horizon Europe setting will be increasingly complex in terms of partnerships and in terms of public-private consortia. So this means that the complexity of IP ownership should really be understood by your researchers, and that's why they need the professional support I was referring to. Then in Europe, there's the whole evolution towards open science and open data, and there is the Public Sector Information Directive. So which means that our research data that are funded by public funding and supported by public funding, that we should, in principle, they should be open to the world. Today, we use the terminology or the statement as open as possible, as closed as needed, meaning that there is a balancing act in sharing and closing data policies within universities. So that's something very new, but very important. Linked to this are the evolutions and expectations regarding economic and societal impact. For instance, what do you do with the intellectual property in COVID research that has been publicly funded, and how do you create access to it by third parties, by industry, etc.? This is a subject of quite some debate within Europe and within the US at the moment. So for universities and for your researchers, it's very important that they understand and that they are supported in dealing with this. And of course, to conclude, novel science breeds novel IP situations, demanding novel IP solutions and frameworks. We had this in biotechnology. For those of you who look at the graph, this means that in the 40s, essentially the foundations of biotechnology were first created by people like Max Delbruck. It took like 40 years before the first commercial applications were there. Today, we have over 700 listed biotech companies on European and US stock exchanges, but in between there is a lot of intellectual property that has been developed in academic settings and that has been turned to economic value, but that has required also quite some new legislation, interpretation of legislation, interpretation of patenting activity, etc. And the same holds today, for instance, with respect to artificial intelligence. Universities are breeding grounds of a lot of artificial intelligence insights, inventions, discoveries that are coming to fruition. The question is, how do we deal with artificial intelligence being linked to inventions, being linked to protection and intellectual property? So quite often, the scientific world does not only need to understand intellectual property rules as they exist today and use them in exploiting and bringing to market their research insights, but on the other side, it's also a cradle for new IP situations, for novel IP challenges that will require novel approaches and novel legislation in order to be fully appropriable and in order to be fully exploitable. So I would like to conclude there. I think this is my almost last slide. So if you just put on the last slide, Axel, then I would like to conclude by look, your academic environment is the cradle of science, science linked to technologies, but if we want to come to a market creating innovations, like for instance, artificial intelligence, we will need to meet in the middle. We will need to have science and appropriate IP protection rules in place in order to reap the full societal and economic benefits from the IP researchers are creating. And that's why they need to understand IP in detail, what it means, how to protect, how to organize, and what may be changing in the near future because of what they have invented. Thanks a lot.
Many thanks to both of you. This has been extremely interesting. And in the meantime, we have a long list of questions. So I'm gonna start with the first one. Maybe Peter, could you tell us how can IP actively support the green economy transition?
Okay, thank you. So yes, the green economy is a transition. So at least from the point of view of where I come from, I do believe that technology has quite an important role to play in relation to the green economy transition, also climate change and many other things. It's not something that's talked very much about in the climate change discussions, for example, and IP almost nothing at all. So it's not that big a surprise. But I do believe that IP actually has a role to play. And what role is that? Well, it can help as part of its innovation ecosystem, as I mentioned in the presentation, meaning that it can help to get innovation out there. I think it was very clear from Koenraad Leuven's presentation here that how for researchers getting out there is really important to get these rights clarified. Now, in more practical terms, a number of intellectual property offices, so the offices where you send your application for a patent somewhere, very often at least. You can also do it to WIPO, but in the national office, they sometimes have what they call a fast lane for green technologies, meaning that if they, according to their definition, your innovation is green, you would get a preferential treatment and get faster through the system. There are also different kinds of pooling of patents, and there's actually, as I think Koenraad mentioned also, there's quite a number of new IP, I wouldn't say products, but new ways of dealing with IP coming out there, based in open economy and sharing and so on. So all that, these new initiatives is something that also I hope can be more and more supported by the international IP system.
Thank you.
Thank you.
Yes, sorry, we have so many questions. Koen, could you tell us why should academia have an IP strategy in the area of open science?
Well, I think it's there is a worldwide concern that scientific insights should be made freely available to the rest of the world in order for the rest of the world to get access and to understand what is happening. So open science is essentially about making sure that applications are available across the globe and that they are available and accessible to. This means that in order to promote, for instance, scientific, we also need to have access to the data, the underlying data, much more clear than it is today. So that's why there is not just an open science policy, but also an open data policy. And that's where it becomes critically important for researchers to understand where they have to protect intellectual property and data in order to be able to bring them to market versus where they can be totally open and accessible for free to everyone. And that's why I was saying, well, we are coming to a kind of nexus where closed and open are two parts of the same coin. So we have to understand as open as possible, as closed as needed, because if you want to transfer your insights to a company, for instance, or to a particular application area, you will have to be sure that it's properly protected and transferable. And this can only be done once your researchers understand that protection is a means this, and that in the area of open science, this does not this does not forego the need to protect and to transfer. So it's two sides of the same coin, but you really need to be aware of how to manage those two sides of the same coin.
Right. You know, I have received like several questions asking something similar, which is, where can we get training in technology transfer? Do you have suggestions how to train scientists in IPR, recommended courses? Can you provide? So there's really a lot of interest in this regard. Maybe you guys can talk about it.
Well, I can immediately one advice to everyone. There is ASTP, and ASTP has marvelous courses on technology transfer. It's actually the professional technology transfer organization in Europe, and they have their American colleague organization, AUTM. Those two organizations on the American continent and the European continent are really leading in educating technology transfer professionals, also in having courses and coaching sessions for technology transfer professionals. So there is a lot of insight to be obtained there, a lot of training to be obtained there. So I would advise everyone to just go to the websites of AUTM and ASTP and select the first courses they want to attend.
Thank you. That's a great advice. Maybe, Peter, could you tell us how will artificial intelligence influence the IP system?
Right. So I can just add to the sources. So as I think I mentioned also at WIPO, we have something called WIPO Academy, where there's quite a number of resources available for understanding better the IP system in general, not only in technology transfer, but in general. So artificial intelligence, yes, well, it's something, of course, that everybody knows is developing really fast at the moment. So if you start to look at some of these pattern databases, you will see, for example, that a lot of the information that is there is very technical. It's not accessible to everybody unless you have a very technical background. It should be, but unfortunately it is not always. There's a lot of patterns out there. I mentioned in our database in Patent Scope, not in WIPO Green, but at WIPO, we have more than 72 million patents. So of course, sifting through all that, classifying all that, this is one of the areas where artificial intelligence is coming in with some strong new algorithm that can help us to do that. We are also in the process of developing that. Translation of technical text is also something done here at WIPO about through machines and so on. So being better at understanding the text in there, generating more readable summaries and where they're useful and so on using AI is something that several companies are working on also. Just a few of the areas.
Right. Super interesting. Thank you. I have here another question, which would be, what would you think are the reasons behind the reluctancy of some universities, research institutions to set up the necessary mechanisms for fruitful technology transfer and IP exploitation? And also, how can these reluctant institutions be stimulated and supported?
Okay, Claudia, I guess I start taking that question. I think first it's about familiarity, and once again, ASTP is very instrumental in this respect. It's about familiarity. It's about understanding what you can do when engaging in taking along IP as a dimension of your research activity. And then you need to understand how other universities are doing this. That's why I also wanted to dwell a bit upon organization, incentives, etc., etc. That's why I also refer to the Leroux advice paper, because this one gives a quite exhaustive overview of what you can do in order to deal with tech transfer in an academic institution. But it's that culture we need to understand, and the leadership the university needs to embrace the fact that if we want to have impact with our research, it is not just about publishing, because publishing is done for an inner circle, quite often for an inner circle of a scientific community. And some of those publications go beyond that inner circle, but many don't. While if you start thinking about intellectual property, you start thinking about products, you start thinking about solutions that will be offered to society, that will be offered to hospitals, that will be offered to people, that will be offered to companies. And then all of a sudden impact takes on a completely different dimension. And the leadership of a university should fully embrace the multi dimensions of impact, not just scientific, but also societal and economic. And once you embrace this, then you will start thinking of your organization. You will start thinking of the culture you need in your organization in order to make this happen. I understand that those are quite soft principles, but they are extremely important if you want to professionalize, because if you professionalize without having a proper drive and a proper culture in place to stimulate IP activities alongside scientific activities, you will never make it successful. So for me, there are many role models you can look at. There is a lot of information in the ASTP context, but first and foremost, you need to want it as an organization. And I do hope that for universities that are still reluctant, watch what their colleagues are doing, and that this inspires them to walk down the same alley.
Right. Peter, any comment on this?
Oh, I think this is more controversial, but just very short. I could imagine there might be some differences in shall we say, the willingness to go into the whole IP area between private universities and public universities. But I hope that it came through my presentation also, that IP right is not only relevant if you want to go for a commercial exploitation of an innovation. It's also relevant if you want to ensure that the innovation that you have come, that it stays in public domain and stays free and available to everybody, because it ensures that nobody else can come in and take a patent on the invention that has been that you have done there. Thank you.
Great. So I see that there are a lot of questions here. Maybe one more very quickly. When is the right time for a startup which does not have any revenue to develop IP strategy?
Well, Claudia, I would say a startup has to think from the very beginning, even if the product is not yet finished, even if there is not new. I guess startups are always looking for investors that back them. And for those investors, IP is quite often the only asset that the start has in the beginning. Of course, the asset of the talent of their founders and their teams, that's highly important. But if you don't this talent into intellectual property, then there are no assets. And if you want to attract the necessary investment to develop and to grow, you will have to show something that attracts investors. And this is most often intellectual property. Actually, there have quite some interesting studies, econometric studies, showing that intellectual property really makes a difference for a startup in its ability to attract funding. So I would advise the startup from the very beginning, never neglect IP.
So I would concur completely with that. It's not necessarily also a matter of going for a patent right away. It's also thinking about how, if you're dependent on other people or partners in developing your innovation, well, make sure that you have a research and development agreement, so that you already from the beginning know how you're going to share whatever may come out of it, so you don't risk to get into these conflicts that I think we have all heard about, terrible stories out there where people fighting about the scraps of an innovation afterwards. So it's really about that. And then when you get further and you got your product and you now you think you need to think seriously about patenting, well, maybe try to do this patentability testing, meaning hire a consultant or a lawyer to help you to understand the patenting market, which markets would be most relevant for you, which part of your innovation is actually patentable and which are not. So you don't waste time on useless applications which cost you money and time. So I think it's not, it's there are many aspects of it. that you need to think about from quite early on.
Thanks. And thanks so much for sharing with us your valuable input and all the amazing experience that you have. And I explained before this presentation, this recording will be available on FRIP Council's website tomorrow, the 9th of October. And later on, you will receive an email inviting you to complete a 1-minute survey about this webinar. So we will be very grateful for your feedback. And please visit our website for details of our forthcoming webinars. Thanks everyone for listening, and in particular, Peter and Koen. This has been a truly pleasure being here and listening to you. So thanks a lot.
Thank you so much.
Thank you so much.
Bye.